In a lot of situations where someone was arrested for domestic violence, they actually themselves are the victims. And if they did use force on the other person, it was only in self-defense. But still, you get arrested, you get a court date, and now you're probably wondering, how do I present self-defense? There's actually a way to do it before court, and in this video, I'm going to be describing exactly that, because if possible, you want to avoid court altogether and get the whole thing dropped. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. And again, in this video, I'm going to be explaining if you yourself were just defending against the other person's aggressions, how to present that before court to the DA to maximize the chances that your case will get dropped before court. Okay, so let's dive right in. So maybe there was a really bad night between you and your significant other. Maybe you're still together, or maybe this is an ex who attacked you first, and you did use some force on them, but you were just defending yourself. The cops come out, they see that the other person has injuries. They either see that you have injuries but don't really care, or maybe you didn't give them any statement about your injuries. Maybe you and the other person were separated for your interviews with the police, and you think, okay, well, I don't want them to get arrested, so I'm not going to say anything about them. Even if they were the aggressor, I'm not going to show my injuries. I don't want to get them in trouble. But what you don't realize is maybe they are throwing you under the bus. And sometimes that's what happens. Sometimes, honestly, the police just come out and they don't like the looks of you. Maybe you have a little bit of criminal history. Maybe you're just the guy and the other person's a woman. Maybe you're bigger than her. Or even in same-sex relationships, maybe you are larger than the other person. And the cops, within seconds, maybe minutes, just make a decision as to who they believe is the aggressor. They arrest you, they put you in jail. Usually it's going to be $50,000 bail, and they've booked you for felony domestic violence. But you may be thinking, okay, but I had injuries too. I actually was just defending myself. So what you may not realize, especially if this is the first time that you were ever arrested, is that after you get arrested, you bail out, right? And you think, okay, I have a court date a few weeks, a few months down the line. You think, okay, there are felony charges against me, or if it was a misdemeanor, there are misdemeanor charges against me. There's a case against me. That's actually not true. How it works is that after you get arrested, one or both of the cops who actually came out and arrested you is going to write up a report. Then they give it to their supervisor. Then their supervisor signs off on it and gives it over to the DA's office. The DA is the prosecution. The DA then has to make a decision, is this a case that we actually want to prosecute? Even the DA knows that these cases are not really investigated very thoroughly before an arrest is made. So just because there's a police report, just because you were arrested, doesn't mean that this is a case that they want to expend their resources prosecuting. Never mind the resources that you expended bailing out of jail, right? But that's a separate issue. So what you can and what you should do is obtain competent legal representation to contact the DA before court and explain your side of the story. So how do you do that? Number one, if you're watching this video right now and you have not taken photos of your injuries, go take photos. Stop the video before you even subscribe, ring the bell. Seriously, go take photos. You need photos. Even if the injury has faded, take photos right now. Email them to yourself so that you can show the date when you took these photos. I know that there is metadata on the photos themselves, but a low-tech, fast option that you can use is to just send this to yourself right now. If you're thinking, okay, but the cops took photos, do I really need to take photos as well? I mean, shouldn't they have those? Should the DA have the photos before they're making this decision that could change the course of your entire life? Yes, they should. But how things should be and how things actually are in the criminal justice system in California are not necessarily always the same. So yes, it would be great if they were organized and they had photos and they also turned over their body-worn videos so they had exactly what the other party said. But that is not always how it works. Many times all that the DA is reviewing when they are trying to make this decision about whether to file felony charges, misdemeanor charges, or drop the case against you altogether, all they have is the police report that the police officer wrote hours, maybe even days after this incident actually occurred, paraphrasing what the other party even said, your booking photo and your criminal history. Many times they're not going to bother to actually upload those photos of your injuries. Because, see, the cops are not working in your favor. That's why you need someone to work in your favor and contact the DA ahead of time. So You need a competent legal representative. You need a lawyer who practices domestic violence, who does a lot of these cases, because a lot of lawyers like to wait until the first court date, which I think is crazy and a horrible strategy for domestic violence, because many times we can get these things dropped beforehand. And that lawyer needs to write a letter explaining your side of the story. Sometimes we can have our client also give their side of the story, but I don't really like to do that without seeing what my client said. Sometimes people are drinking, sometimes they don't remember, sometimes it's a very chaotic situation and can be traumatic to get arrested, and there may be a few details that maybe get mixed up a little bit in your mind. So I don't like to have my clients write a statement. I like to write one for them, because then it can't be used against you. And if there's a discrepancy, okay, oops, the lawyer got something wrong, that can't be used against you. If the victim's on your side, and they agree that it was self-defense, then I want them to write a letter. And if you're wondering, are they going to get in trouble? Almost certainly not. They're not going to get in trouble. Photos of your injuries. And then with that, I also like to attach character letters and a letter describing you as a person. This is called a character packet or mitigation packet, where I describe all the good things about you. So I'm not just saying, hey, this is self-defense, here's what actually happened. I haven't seen the police report, because I, as the defense attorney and you as the defendant, can't actually get it until charges are actually filed in court, at least not in California. So I haven't seen what's in there, but here's our side of it. But also, here are character letters showing that my client is a good person. Here are people vouching for him. Here are his hopes and dreams for the future. Here is his education, job history, any hardships that he's experienced. Going into all of that, it helps a lot. So we give all of this to the prosecution, talk to the prosecution, and try to get them to drop it before court. And many times, especially if this is your first time getting arrested, we are able to do that. But what's really important is that you have an attorney do this before the first court date, because basically how it works is there's somebody at the prosecutor's office whose job it is to read these police reports and anything else that's in the file and put your case on a pile. Is it on the felony pile where they file felony charges, misdemeanor file, or is it on the pile of cases that they don't actually prosecute? Now that person has a lot of discretion, and their job is to just look through this big pile of documents and figure out where everything goes. Their job isn't actually to prosecute. But if your case ends up in the felony pile or the misdemeanor file, now they're going to assign a prosecutor, a lawyer, whose job it is to prosecute you, to get you. At that point, it's going to be a lot more difficult to show the DA, hey, actually, this was a self-defense case. Why don't you go ahead and dismiss? Because that person's job is to prosecute you. I'm not saying it never happens. It does happen sometimes, but it's an uphill battle. So it's really important that you contact an attorney very early on to make sure that you maximize your chances of, before that attorney is sorting the cases into the piles, to make sure that you have that attorney contact the DA and give your side of it. You want your side to be heard. This is even if you made a statement to the police. Because in addition to your attorney showing the DA that you are a good person, showing evidence of self-defense, whatever evidence you may have, the attorney is also showing the prosecutor that you have an attorney. They're going to fight this case, that this is not going to just be an easy conviction, easy at the first court date, just take the first offer like a lot of people do when they use the public defender. This is going to be a case where if they want to prosecute you, they're going to have to use a ton of resources, because you are here to fight for your freedom, for your future, for your record. You want to keep it clear because you care about yourself and you care about your life. And sometimes that can be the most important thing to show the prosecution. I hope you found this video helpful. If you did, please don't forget to like, subscribe, and ring the bell. And if you do need help with a criminal case in California, feel free to give me a call. You can find my number down below. You can also book a consultation via the link down below.